A seed. It's so small, but it's the very beginning of almost everything that lands on our plates. And the laws that govern that tiny seed, they are incredibly complex. They have a huge impact on farmers, on businesses, and ultimately on national food security. So today, we're going to dig into India's really unique and powerful answer to a global dilemma, a model that, believe me, other nations are watching very, very closely. It really all boils down to this one fundamental question. Who owns a seed? Is it the person who carefully saved it from last year's crop, or is it the company that engineered it in a high-tech lab? Yeah, the answer is not simple, and how you answer it pretty much shapes an entire country's agricultural system. So, you've got two creators here. On one side, you have the farmer. For literally thousands of years, farmers have been the keepers of our planet's agricultural biodiversity. They're conserving, improving, and sharing seeds. It's a tradition that's as old as farming itself. But on the other side, you've got the modern plant breeder. They're investing a whole lot of money and years of scientific research to develop new varieties that might give us higher yields or fight off diseases. And right there, you have a natural tension. So, how in the world do you solve this conflict? How do you balance ancient tradition with modern intellectual property? Well, instead of choosing one over the other, India decided to build its own, custom-made solution from the ground up. This whole story really gets going back in the 1990s. As part of these big global trade deals, specifically the TRIPS agreement, India was told it had to create a system to protect plant varieties. It was a real fork in the road. They could have just copied a standard Western-style patent law, or they could design something totally new, something tailored for their own people and their own economy. And this is where this really cool legal idea comes in, sui generis. It's a Latin term, and it literally just means of its own kind. In the legal world, it means you're creating a unique system for a very specific purpose. So instead of a one-size-fits-all patent approach, a sui generis system lets you build a more flexible framework, one that can protect the rights of farmers right alongside corporate breeders. And that is exactly the path India took. In 2001, it passed the Protection of Plant Varieties and Farmers' Rights Act, or the PPV&FR Act for short. And this wasn't just another law. It was a landmark piece of legislation designed to pull off a very, very delicate balancing act. All right, so let's break this down. Let's look at the first half of that balancing act, how this law specifically protects the rights of the farmer, who is, without a doubt, the cornerstone of Indian agriculture. And this, right here, is where the law becomes truly powerful. It says crystal clear that a farmer can save, use, sow, resow, exchange, share, and even sell their farm produce. And that includes the seed of a variety that's technically protected. This isn't just a recommendation. It's taking those ancient traditional practices and writing them into modern law. Now, here's the crucial little detail that makes the whole system work. A farmer can sell their grain, which naturally includes the seed, but what they can't do is package it up and sell it as branded seed under the protected variety's official name. This is the big compromise, right? It respects the farmer's right to their own harvest while also protecting the breeder's investment in that specific brand. And believe me, this isn't just a theoretical protection. The results, well, they speak for themselves. As of today, an absolutely stunning 4,845 varieties that were developed and conserved by farmers themselves have been officially registered and protected under this very act. And this chart just drives that point home perfectly. As you can see, varieties registered by farmers make up more than half, 53%, of all the registrations. This shows us that farmers aren't just being passively protected by the law, they are its most active participants and the ones benefiting the most. Okay, so now let's flip the coin and look at the other side. To balance out these really extensive rights for farmers, the law sets a very high bar for the breeders. If you want to register a new variety, you have to run a scientifically rigorous gauntlet. The road to registration isn't a short one. It starts with a detailed application, which then goes through an initial screening. If it passes that, it moves into the most critical phase, a bunch of scientific testing. After that, the details are published so the public can raise objections. And only then, if it clears all those hurdles, is a certificate finally issued. The whole thing is designed to be super thorough and transparent. That scientific part, the DUS testing, is really the heart of the process. To qualify for protection, a new variety has to prove 4 things. First, it has to be novel, meaning it hasn't been sold commercially before. It's got to be distinct, so you can clearly tell it apart from any other known variety. It also needs to be uniform, which means all the plants have to show the same key traits. And finally, it has to be stable, staying true to its form generation after generation. It's a high bar to clear. So once a variety gets registered, the breeder gets exclusive rights, but it's not forever. Protection lasts for 18 years for things like trees and vines, and 15 years for most other crops. From an economic perspective, this is really smart. It gives breeders a clear window of time to make back their research and development costs, which encourages more innovation, but it doesn't lock up that genetic material forever. Okay, but what about enforcement? I mean, a system like this is only as good as its ability to stop people from cheating, right? Well, the PPV&FR Act has some serious teeth when it comes to deception. Let's just look at the penalties for one specific offense: applying a false or misleading name to a seed variety to trick buyers. The consequences are pretty steep. You can face prison time for up to 2 years, and you could also get hit with a fine of up to 5 lakh rupees. This protects everyone in the system, but especially the farmer who's buying that seed. And the law has a really strong message for repeat offenders. If you get caught a second time, the penalties get even harsher. We're talking up to 3 years in prison and fines that can go all the way up to 20 lakh rupees. The message here is loud and clear. The integrity of the system will be protected. So we have protections for farmers and we have incentives for breeders. But let's zoom out for a second. What does all of this really mean for the bigger goal of national food security? Well, you can see the momentum behind the system right here. The number of registrations just skyrocketed in recent years, with 2023 and 2024 being absolute peak periods. This isn't some dusty, slow-moving government process. It's a dynamic system that points to a healthy and growing agricultural sector. Looking at this from an agricultural economist's point of view, the Act creates what we call a virtuous cycle. By protecting breeders, you stimulate R&D. By having a transparent registry, you help make sure high-quality seeds are available. By recognizing farmers, you reward them for conserving biodiversity. And all of those things together lead directly to increasing agricultural output. And this brings us back to what is probably the Act's single most important contribution to long-term food security. By empowering and rewarding farmers for saving those thousands of local varieties, it's actively building this huge, diverse genetic library. This agrobiodiversity, it's the nation's ultimate insurance policy. It's a critical buffer against climate change, new pests, and threats we can't even imagine yet. India's PPV&FR Act is, when you step back and look at it, a remarkable and successful balancing act. It somehow manages to respect these deep, ancient traditions of farming while also encouraging cutting-edge innovation. But that leaves us with a big question for the future. As agricultural technology, everything from genetic engineering to AI, starts accelerating faster than ever before, how can this delicate balance continue to evolve to secure the harvest and feed a nation?